Everybody, welcome back to the Starved Rock Murders. I'm your host, Andy Hale. So I've taken a deep breath. Whew. A lot has gone on, as you all know, the last few weeks. And so let's start with Chester Weger. He passed away, as you know, most of you probably know, comfortably surrounded by his family. And what a journey I'd been on with Chester Weger. And it was so sad. I already miss him so much. 86 years old, arrested at 21 years old, tried and convicted, spent over 60 years in prison, got out on parole a few years ago, but never gave up the hope, never gave up the fight to prove his innocence. Chester Weger was such an inspiration, was such a humble, gentle, kind soul, cared more about others than himself. I wish you all could have met him and spent time with him like I did. He really was a wonderful person, and he will be missed. His struggles are over now. He is at peace. He has passed the torch to me. I will gladly take that torch now and continue his fight for justice. But just a little short moment of silence for Chester Weger. Chester, I miss you and I love you. Let me say this. People have asked me, how am I doing? People have checked in. I really appreciate everybody that's reached out to me. And I want you all to know this. It was hard losing Chester. It was hard having the court rule against us at our third stage hearing. But here's where I'm at peace. I'm at peace in that I know we proved our case. I'm at peace because I know we proved our case at that evidentiary hearing, and I have proven the case on this podcast time and time again that Chester Weger is innocent and had nothing to do with the Starved Rock murders. In my opinion, anybody who thinks Chester's guilty, respectfully, just doesn't know the facts, and I don't expect everybody to know all the facts. Like, why would you? Or they have a vested interest in the case somehow. Otherwise, if you do know the facts and you don't have a vested interest, I think it's clear as day that Chester Weger had nothing to do with the Starved Rock murders. And Chester's passing and us losing the court hearing, you know what it reminds me a little bit? I've told this story. It reminds me about a little bit of the Grinch, how the Grinch stole Christmas. The Grinch steals all the Who's down in Whoville, all their Christmas presents. And he can't believe it the next morning when they all get out in the little town square, hold hands, and still sing and celebrate. That's how I feel. Yeah, I lost the court ruling. The judge ruled against me, but what no one can take away from me is the journey I was on and the time I spent with Chester Weger and his family and all the things we accomplished and proved and all the evidence we uncovered. I'm like a little Who down in Whoville holding hands and singing. I'll always have that. No one can take that from me. So I am at peace in that sense, and I feel powerful in that sense. I feel amazing in that sense. I feel incredible what we accomplished in the 8.5 years I've worked on the case. I feel so proud of our team. I feel exhilarated, and it's been an amazing journey. And it's not over. Like I said, it's not over. We will continue to explore all our options and to see what else we can do. I'll continue to investigate. I'll continue to find out whatever I can. The hardest part with the court ruling was, respectfully, I think the judge got it wrong legally. The judge got it wrong factually. And if Chester was still alive, I would be very, very confident that this court order would get reversed on appeal. Very confident. But the saddest part is, because Chester's not here, we can't pursue an appeal. So we are stuck with this trial court ruling, which is really disappointing because I would have loved to have the opportunity to have an appellate court review the judge's order and weigh in. Like I said, I feel very confident we would have got that reversed and would have got back down into court, probably with a different judge, and our journey would have continued. But Chester's passing ended any chance to appeal. But like I said, wheels are in motion. I'm looking into some things, several things. You haven't heard the last from me yet. Okay. So I want to talk a little bit more specific today about the court's ruling. And before I do that, one more thing. Thank you to everybody that supported Chester and his family and me, the people that have reached out to me, sent emails, sent letters, sent cards, all the people that attended the court hearings, that core group, you know who you are, that came to every court hearing and offered so much love and support from the bottom of my heart. Thank you. It has meant so much to me and to Chester and his family. Sincerely. And I'm not done talking to y'all yet. We'll see each other again real soon. So let's talk about the court hearing. The way I argued this at the evidentiary hearing, my lead argument was the DNA evidence. And then I also combined that with people who testified. And what the standard was whether our new evidence collectively would be enough to potentially, when you combine it with the old evidence, potentially change the trial result on a retrial. And I think we overwhelmingly met that burden. So what I want to do with the DNA evidence, let me just I want to read to you the transcript of my oral argument to the court when I argued this in front of the court. So just picture you're in court right now. These are the words I said, and I'm gonna read those to you now about the DNA evidence, okay? And the way I did my oral argument, I first talked about all the weakness in the criminal trial, how weak of a case it was, how there was no corroboration for the bogus confession. I walked through it in detail, that it was a very weak criminal trial, and in my opinion, it would not take much at all. It would not take much new evidence to probably change the trial result. And we provided a ton of new evidence to the court. So here we go. Let me just read through this. Be patient with me. Listen. Get a little cup of tea. Put your feet up. Get cozy. Go get a little snack. This is my oral argument from court. Okay. So let's talk about the new evidence we presented. That's how the case got investigated. That was the trial. Now let's talk about the new evidence, the hairs found on Francis Murphy. Our first witness was Dr. Christopher Palnick from Microtrace. He testified he went to the evidence inspection, cataloged all the evidence, and took photos. And what's shown here on this first photo is the envelope that talks about it being taken from the left index finger of Mrs. Murphy. And then there's 3 glass slides above it all with the number 5 on them. So you've got 3 slides on the boxes, 1 slide in the envelope. We walked through all these photos. These are in evidence. And I want to get to the photo where the bottom photo here, AH counter 342. Dr. Palnick talked about it was a hair between 2 glass slides with red tape at the end. And he noted that, and you can see this on the slide at the top. There's glass etching with a diamond stylus saying where that hair came from, the left index finger of Miss Murphy. It's meticulous record keeping that they wrote in there with a diamond stylus. I cited my brief trial testimony from an Illinois state trooper who talked about using a diamond stylus to label slides that he was preparing for hairs found on Miss Oding. So it was clearly a very meticulous practice of the Illinois State Police to document those hairs, to preserve them, and to show where they came from. And Dr. Palnick talked about this hair that's in this glass slide with the tape. It is secure. It's secured in the glass. And even if the hair would have come out, which it didn't, and somebody would have touched it, it gets washed before you do any kind of DNA testing on it. So there'll be no contamination on the hair. So Dr. Palnick talked about what he observed with how the hairs were maintained, how the glass slides were maintained, how everything was labeled. We cite that in our brief. He talked about how everything was reliable to him in terms of what he saw with the hairs and how they were preserved. And then he also showed, this was in the file, these photo micrographs that were done back in 1960. It just shows you how meticulous the state was when they analyzed these hairs found on Mrs. Murphy. You know, these bottom two photos, that's not anything Dr. Palahniuk did. These photo micrographs were done by the Illinois State Police back in the day. And there's a bunch of them in the photographs in the documents that we introduced in evidence. And that's all part of the record. And so that hair, we showed all the photos of those hairs that were found on Mrs. Murphy, collected, preserved, meticulously labeled, and analyzed. That hair then, the one in the glass slides with the red tape, gets sent to Najee Bradley at Bodie, who was our second witness. She analyzes the hair, and what does she say? It was an anagen hair with a root with a 4+ rating of follicular material. She said she scaled it on a scale of 1 to 4. This was a 4+. There was that much follicular material. And this is her testimony from page 113. So the anagen phase is where the hair is securely attached to the hair follicle. It's receiving a blood supply and nutrients, and it's the actively growing phase. So when the hair is actively growing, that's the anagen phase. And she went on to say on the next page, on page 123, so an anagen hair that has the 4+ root material or follicular material, it's usually associated with a hair that's been forcibly removed. Let me say that again. Forcibly removed. So one that's been like plucked out of the scalp from some type of external force. That's because the anagen hairs, they're securely, like in the actual follicle attached, receiving nutrients and blood supply. So in order for them to be removed, it takes some type of force to remove them. Like when you take a pair of tweezers and you pluck out your eyebrow hair, your chin hair, and it hurts. That's usually an anagen hair because it took some type of external force to take that out. Okay, that's what Najee Bradley said. So that hair in the glass slides with the red tape on it that Chris Palahniuk documented, that's got the engraving with the diamond stylus that was done in 1960, it was found on Miss Murphy's left index finger, and it gets sent to Bodie Technology. Najee Bradley does her analysis of the hair's growth phase, texture. She showed you photos and she explained that these photos of how this shows the root material of the hair she examined. These are all photos of the same hair, and her testimony walks through her explaining how this hair has a root and significant follicular material. And in her notes, her contemporaneous notes at the time, this was in the inventory report, which is Exhibit 6, she noted anagen phase, 4+ follicular material, 6 centimeters in length, might be suitable for DNA analysis. That was from Najee Bradley at Bodie. She then passes the baton to Keely Coleman at Bodie, who does the DNA testing on that hair that's got the root and the 4+ follicular material. Her testing shows it's a male profile, not Chester Weger. That's what the DNA shows from that hair found on Mrs. Murphy. This is, Your Honor, I cannot overstate this. Let me just pause. This is a DNA exoneration. This is a DNA exoneration. That hair found on Miss Murphy came back to somebody other than Chester Weger. That proves this man's innocence. Chester Weger didn't commit the crime with other people. It wasn't multiple offenders. His confession, his ridiculous confession, was he did it by himself on his lunch break. That hair shows Chester Weger is innocent. It is a DNA exoneration, loud and clear. I'm saying this in a normal voice, but if I could climb to the top of the tallest mountaintop and scream it as loud as I could, I would. It is a DNA exoneration. And let's talk about that. Where is that hair found? The left index finger. So let's hypothetically talk about what the state's going to say. It's not like the hair is found on the bottom of her shoe or on the back of her coat or under her armpit. It's found in her left index finger, which is a finger you would use to grab somebody, struggle with, and potentially grab a hair out of somebody's head. they find it on her left index finger. It's not just one hair either. It's not like it was just one hair and it just blew in the wind. Dr. Palahniuk said there's more than one hair because there's a full hair in the glass slide with the red tape, and those other 3 slides on the wooden glass boxes all had hair fragments. That was another hair or 2. So there was more than one hair found on Frances Murphy's left index finger. It's an anagen hair. It's actively growing. It has a root. It's got 4+ follicular material. And the state itself in 1960 sent it to be analyzed and compared to Chester Weger because they knew darn well it was going to be related to the crime, and they wanted to know whose hair it was because that person would have been involved in the crime. That's the hair we're talking about. And with all those characteristics, and none of this coming back to Chester Weger, that is a DNA exoneration loud and clear. And I could sit down right now. We've met our burden simply by this, overwhelmingly. But let me continue. We went a step further. We brought in a gentleman from Othram. Othram does cutting-edge genetic genealogy. They get genetic sequences and they try to identify an individual with a particular piece of evidence. CODIS is restricted in terms of who's in the CODIS database. I would note that Colby Lesone noted that his office works with the Will County State's Attorney's Office to identify Jane and John Doe bodies, which I think gives a lot of credibility to the work that Othram does. And I think it makes it difficult for Will County to say, who are these Othram people? How could they be any good? The Will County Coroner's Office uses them. It's cutting-edge genetic genealogy. His analysis showed, Othram showed that the hair belongs to one of 3 local brothers, Leo Bray, Charles Bray, or Edward Bray. Chester Weger didn't have to do any of this. The DNA result is a male profile, not him. That's all that matters, and it doesn't matter which brother it came from. But it's interesting that it came back to one of 3 brothers local to the area. That's who the hair came back to. Now, I'm going to address this because I think the state's going to try to make this point disappointingly, but let me talk about it. Edward Bray died the same day the women's bodies were found. Let's pause there. I thought during the hearing when the state was trying to act like that was something in their column, I clearly put that in the Chester Weger column. Edward Bray dies the same day the women's bodies were found? That's awfully weird that he dies that same day. Really? His death certificate is signed by 2 people. I highlighted a Dr. Cross, and below that is Hulse, okay? And I know from the record in my brief, Your Honor, I mentioned a cite from Mr. Hulse explaining Mr. Hulse is the deputy coroner. Dr. Cross is the coroner. So all we know from this death certificate is that 2 people signed it, Dr. Cross and Dr. Hulse. But what we do know is this: the Manley and Hulse funeral home is in Utica, Illinois. The women were taken to the Hulse funeral home in Ottawa, Illinois. Okay? The state wants to get up here and argue now is that somehow, with no foundation, there's no evidence of any of this. All they've got is a name on a death certificate. That's all they've got. They've got Mr. Hulse signed this one, and Mr. Hulse was present at the funeral home where the women were. That's it. That's all they've got. That's all they've got. But their brief says it, I think the words were, it's much more highly likely that this is how the hair got on there, that presumably Mr. Hulse is doing something with Mr. Bray, somehow gets an anagen hair, plucks it out with force, more than 1, 2 or 3, gets those on his body, unbeknownst to him, travels across town to another funeral home, sees Mrs. Murphy there, goes right to her fingers, leans over her, and the hair falls out onto her fingers, this anagen hair. And now we've got this cross-contamination. The state wants to argue that was more likely. Shame on the state. Shame on the state. They want to argue it's cross-contamination, and that's how it happened, when this is an anagen hair, more than 1, found on her finger. It is so overwhelmingly a DNA exoneration. And there's no foundation for any of this theory the state has about the contamination. There's no record of what Mr. Hulse did, where he went, what he did with the bodies, where he walked, what he touched, what he did, nothing. This is all something they want to make up. It's a clever little argument, but it should be rejected summarily. That is what I argued to the judge during our arguments a few weeks after we had the 3-day evidentiary hearing. Now I want to read a little bit of what the state presented. Let me first start with the state's brief. So after we did the 3-day hearing, both parties submitted lengthy legal briefs summarizing their version of the evidence. And then after that, a week later, we had oral arguments. So the state in their brief, and this is at page 41 and 42, this is what they say about the hair and Edward Bray and Deputy Coroner Hulse. Okay, I'm going to read this verbatim. It is much more highly likely that this hair may have belonged to Edward Bray, even assuming an uncontaminated chain of custody, because he died on the morning the women were found, and his body was officially cared for by the same deputy coroner who recovered the victims' bodies and whose funeral home was the location where Dr. Maloney performed the autopsies of the 3 women. Defendants' experts admitted that transfer of a hair was quite possible, and given Norman Hulse's connection to both Mr. Bray's death and the victim's recovery on the very same day, the most likely inference of all of this is a simple case of transfer of the single hair. Deputy Coroner Hulse even testified that part of his equipment was a morgue cot with an attached, quote, fastened and very likely reused zipper bag. One of the victims was placed in this bag. Of course, hair can get pulled out by a zipper. Okay, that's what the state said in their legal brief. And then in the oral argument, this is part of the state's argument about the hair. This is page 130. But the people did try to see if there was a connection. And lo and behold, one of the Bray brothers, it was figured out that this deputy coroner, Mr. Norman Hulse, who testified personally at the trial that he observed these 3 women's bodies, he saw Edward Bray and the 3 victims within a 48-hour time frame. All the defense experts were consistent. They acknowledged that hair can transfer by way of contact transfer, and they consistently acknowledged that none of them could say that the hair was even at the St. Louis Canyon or how it got there, or that Edward Bray was at the St. Louis Canyon. But the defense still wants you to make more than a reasonable inference, a giant leap, that because 1 out of 43 hairs belongs to a Mr. Bray, that Mr. Bray was the murderer. Mr. Bray didn't confess to this murder. Mr. Bray didn't reenact the offense. The defendant did. And then later, the state says at page 153, we don't know, for example, if it was taken from her glove after Mr. Norman Hulse saw Edward Bray, and then he saw the 3 victims. Okay, so let me unpack that a little bit. The state in their brief says that his body, Edward Bray's body, was officially cared for by the same deputy coroner. And they say in the argument that he saw Edward Bray. All we got, all the state presented, this is the death certificate of Edward Bray. Okay, I'm going to post this on the Andy Hill Podcast website. I'm going to post the judge's ruling. What this death certificate shows is that Edward S. Bray died on March 16th, 1960, which is the day the women's bodies were found. It said he was single and he was a guard at the Seneca shipyard. He was born on January 29th, 1900, so he was 60 years old. He died of a coronary occlusion. And here's the part down here. The death certificate is signed by the coroner, Dr. Cross, and it's signed by the deputy coroner, Mr. Hulse. And it's dated March 17th, 1960, which is the day after the women's bodies are found. That's all the state had. That's all we've got. There's no evidence Deputy Coroner Hulse had any contact with Edward Bray's body. There's nothing, it was in the record, about Mr. Hulse having any contact with Edward Bray's body. All we know is he signed the death certificate on March 17th, and he was the second person to sign it. And it's also signed by the coroner, Dr. Cross. That's all we know. So when the state says that Mr. Hulse, he cared for Edward Bray's body, we don't know that. And when they say that, Hulse saw Mr. Bray and the women both within 48 hours, we don't know that. We have no foundation at all for what Norman Hulse did in pertaining to Edward Bray. Nothing. It's just speculation. There is no foundation. And as to the women, Norman Hulse testified at Chester Weger's criminal trial. He testified he went into St. Louis Canyon around 3 or 3:30 in the afternoon when the women's bodies are found, and he got within 25 feet of the cave because it was taped off. It was roped off. He didn't have any contact with the women's bodies in the canyon. He said, we brought some cot and zipper bags to the canyon. He mentioned Dr. Cross was down there, and then when he returned around 6:30, the bodies had been placed onto cots, and they were taken to the preparation of his funeral home. And that's where Dr. Maloney did the autopsy. So there's no evidence even of Norman Hulse interacting with Francis Murphy's body. There's nothing. I mean, there's literally nothing. But yet, what I just read you, that's how the state argued, and what they said in their brief, much more highly likely what happened. Their version, that somehow Mr. Hulse interacts with Mr. Bray, gets this antigen hair with a root on him, somehow goes, because that's at the Utica funeral home, goes across town to Ottawa to another funeral home, and somehow deposit this hair on Francis Murphy's left index finger. That's what the state argued was much more highly likely than what I argued, which is that this hair is on Francis Murphy's left index finger, this antigen hair with a root, because there was a struggle and she grabbed it from her attacker, and that Edward Bray was one of the men in St. Louis Canyon. I think my argument is much, much, much more persuasive. And I actually wasn't worried about this. This is the reason I thought we would win the hearing. I thought the DNA evidence alone was enough to carry the day in a case that was so weak, where it was a confession-only case, a ridiculous confession at that, of Chester Weger bludgeoning these three women on his lunch break and going back to work. If I would have presented at a retrial this DNA result, that the hair found on Francis Murphy's left index finger, which, by the way, is the same finger where the tip of her finger was missing post-mortem. The tip of her finger was missing post-mortem. It's the same finger. If I'd have presented that at a retrial, I think, yes, the result would have probably been different. Because at a retrial, the standard is not conclusively proving Chester's innocent. The standard is probably a different result at the retrial. In a criminal trial, the standard is guilty beyond a reasonable doubt. And I strongly believe, yes, that DNA result, the genetic genealogy result, linking that hair to Edward Bray would have been reasonable doubt, for sure, without even presenting any of my other evidence. This is the disappointing part about the court, and I'm going to read you part of what the court said at page 30 of its ruling. I'm going to post the whole ruling. Okay. It's painful to go back and read this again. So the court first said, leaving a strand of hair at a murder scene is not so common that jurors expect to see it in most cases. Okay, I'm not sure what that means. I've read it 50 times. Let me read it again. Leaving a strand of hair at a murder scene is not so common that jurors expect to see it in most cases. So I guess my argument would be there was a violent struggle in that canyon, a violent confrontation. And so the fact that there's a hair, and then more than one, hairs on Mrs. Murphy's left index finger would be significant. The jury would have definitely found that significant. All right, let me read you the next sentence of the court's order. The hair's relevance as evidence from the murder is diminished by the fact that a person who matched the hair died on the morning of the same day Mrs. Murphy's body was discovered, and the same deputy coroner handled both bodies. Okay, let's pause there. The court's saying the evidence is diminished. Well, the court says the same deputy coroner handled both bodies. As I just said, all we know is Mr. Hulse signed Edward Bray's death certificate on March 17th, the day after the women's bodies were found, and Mr. Bray was at a funeral home in Utica. And we don't know what Mr. Hulse did exactly with the women's bodies. I read you a summary of what he testified to at trial. There's no evidence that he interacted specifically with Frances Murphy. So I think the judge respectfully got that wrong, factually. The judge then said, the defendant's assertion that the hair must have come from the killer are compromised by the recognition that, to be true, it means a 60-plus-year-old man was sent to Starved Rock to assist in the killing 3 women at the end of a long canyon. Okay, I take issue with that as somebody who's over 60 years old. I don't think there is a single 60-year-old guard at the Seneca shipyard is just as capable of murder as Chester Weger, the 21-year-old dishwasher at the Starved Rock Lodge on his lunch break. There's nothing about Edward Bray's age, being 60 years old, that in my opinion makes it unlikely he could have been in that canyon. I believe, as I've talked about in this podcast, there were multiple offenders down there. His hair is down there. He's one of the people. And so the fact that he was 60 years old doesn't change a thing. It doesn't change a thing in my mind. And I was surprised to read that. And I also think, like I said earlier in my oral argument, I think it's weird. I think it's pretty weird that Mr. Bray dies 2 days after the murders. Could it be this 60-year-old had a heart attack because of all the stress and what he went through down in the canyon? I think it's odd he dies 2 days later. And like I said, I think that supports Chester Weger's version of events, not the state's. So then the court says, based on the totality of the circumstances, the court does not conclude that the hair on Mrs. Murphy's glove must have come from the killer, or that the hair is conclusive proof of defendant's actual innocence. And again, we take issue with having to have conclusive proof of innocence. We just had to show that the trial result would have likely been different. So I thought the DNA should have carried the day. I thought our DNA was overwhelming. You heard how the Will County State's attorneys argued it for the state. You heard how the judge ruled in his order. I respectfully disagree with that. I think the court got it wrong factually and legally. And I wish we would have had a chance to argue this on appeal. It's just too bad we don't get a chance to do that. One of the things that we also thought the judge did incorrectly, respectfully, in the ruling was the evidence, the new evidence is supposed to be assessed collectively. And does it collectively potentially probably change the trial result? The court instead went through item piece by piece and said, this isn't enough. This isn't enough. This isn't enough. This isn't enough. Instead of taking it all together collectively and assessing whether collectively the evidence was enough. So I think the court applied the wrong legal standard when assessing our new evidence. And that would have been one of our big issues on appeal. The court, I think another legal error, the court basically treated the trial evidence as gospel, as absolutely true and unassailable. And instead, what we believe the court should have done was to take a fresh look at the trial evidence and make its own determination of how strong it was. And we pointed out a lot of weaknesses in the state's trial evidence. For instance, the scratches evidence. The state presented several lodge employees to say they saw these dramatic scratches on Chester's face. Oh, on his cheek, on his chin, on his chest. I mean, you would have thought this guy was a boxer who just had a 12-round prize fight. We presented, and I think this would have been new evidence because Chester Weger didn't see these, Illinois State Police memos of interviews with Chester Weger in the days and week after the murders, where they interviewed him and then interrogated him for 2 hours. There is nothing. There is nothing, no mention of any scratches, marks, anything on Chester Weger's face when he's being interrogated. Okay? When they're basically looking at all the lodge employees as potential suspects. And all the scratches testimony was developed 8 months after the murders, when the state's attorney's office went back to interview people in a very badgering and misleading way. So that's just an example where we poked holes in the scratches evidence. We pointed out how the state talked about the twine, but the twine could not be traced to the lodge or the crime scene. We talked about how some of the crime lab handwritten notes of a meeting with the crime lab showed that the log wouldn't have been the murder weapon. It was too weak. We presented David Fowler, forensic pathologist, to talk about how the log would have been damaged by all these blows. All the women had fractured skulls. The log would have had severe damage. He even testified that he had a case where somebody struck somebody else in the face with a wooden pickaxe, and the wooden handle fractured from 2 strikes. These women had their skulls broken, and Dr. Fowler testified that the skull is like a helmet for your brain. It is hard to break and fracture a skull. He thought the murder weapon was something like a tire iron, a baseball bat, a steel bar. And so we poked all these holes in the murder weapon. We provided a new report from 1960 that nobody knew about, that they tried to match the tree, the log found by the crime scene, to trees in St. Louis Canyon. They couldn't. It didn't match up to any of those trees. So how did it get there? Did somebody bring it? What's going on with it? Anyway, the point is, we thought the judge made legal error by taking the criminal trial as absolute gospel, as persuasive. Chester Weger confessed. Boom. We thought the judge should have taken a fresh look at the evidence, not simply rubber stamped the 1960 evidence, but taken a fresh look and weighed it in with its own opinion, which the court didn't do. And unfortunately, again, we would have liked to have raised that on appeal. We won't get the chance to do so. Let me just talk a little bit now about the witnesses, because even though we had the DNA, I thought was enough to win, we had several witnesses that we called as well. And I thought all the witnesses in their own right were authentic and real. So I'll go through this in the way that the judge describes him. So Roy Tyson is the guy from Hennepin who was friends with Smokey Rona, and said how Smokey Rona told him this story about he was hired by the Chicago Mafia to organize these murders because one of the husbands wanted his wife killed. I thought Roy Tyson had no dog in the fight. I thought he testified honestly and authentically. Yeah, his story's a little crazy, but stories can be crazy. And one of the things the court said was, the court also finds, after observing Tyson's demeanor and manner of testifying, that the testimony he's offering is also not credible. It was evident that Tyson was anxious to assist the defendant in any way possible. And the court talked about how he reached out to me on Facebook, how he was a fan of the podcast and the Facebook page. I don't really think that's fair. That somebody found me through my efforts in doing the podcast and things. That was the whole point, to try to find people that know something. The court said on cross-examination he was noticeably defensive in his responses. I take issue with that. I didn't see that. I thought Roy Tyson held up extremely well in cross-examination. I actually was impressed with how well he did in cross-examination. So the court found that Mr. Tyson was not credible. Then we also called Randy Reynolds. Randy Reynolds, such an authentic, honest guy. I thought he's the one who went to Bill Dummett's retirement party and heard him say, was standing there when he said, I thought Chester Weger was innocent, but I got the son of a bitch to confess. The judge said this about Randy Reynolds. The court had the opportunity to observe the demeanor of Mr. Reynolds while he testified in his manner of speaking. His answers on direct examination were more concise and confident about general broad statements, but when questioned on cross-examination about the details, his manner of answering questions changed and he was less clear. I disagree. I didn't know any of that. I didn't think any of that was fair. He also says that about Randy Reynolds, and this is on page 16 and 17, when Randy told the story about what he heard, he said it was not believable. The court said, I'll just read this line. The court accepts that Reynolds attended the party, but the court finds that the surprisingly detailed comment about what Dummon said, namely that Chester Weger was innocent and I got him to admit it, is not believable, especially since he could remember few details about who was present for the statement. He admitted that the Starved Rock murders did not mean much to him back then, and it was not until he had conversations with a family member interested in investigating the case 40 years later that he decided to say anything about it. Not believable. I wish you could have seen Randy Reynolds. And I've met him several times. He is honest as the day is long, has no dog in this fight, told the story from the heart. There's no doubt this is what he heard. He told his wife that night on the drive home, like, what the hell is up with Dummett? Why would he say this? I was really surprised the judge said that Randy Reynolds' testimony, what he heard, was not believable. I thought Randy Reynolds was extremely believable, and I couldn't say that any stronger. I thought Randy Reynolds was so authentic and honest. And anybody out there that knows Randy Reynolds, you know what I'm talking about. James Wood is the guy who was a kid. He heard his dad. His dad was good friends with Wayne Hess. And one day his dad came home and said, basically, Wayne Hess had said, that they had regrets about what happened to that kid. And clearly they were talking about the Starved Rock murders. The court just said, well, this single indefinite comment would not alter the guilty verdict. Again, our position is it doesn't have to alone alter the guilty verdict. It's taken in collectively with all our evidence. The DNA, Randy Reynolds, Roy Tyson, James Woods. Look at it all together, not isolated. Melissa Smith, she was the one whose grandfather told her when he was dying of cancer, he was in the Chicago Mafia, and he knew the guy that got convicted of the Starved Rock murders was innocent because he handpicked the guys that went down to Starved Rock Park and committed the murders at the request of one of the husbands. Here's one of the things the court said about her. The court does not find Smith's testimony credible based on her demeanor and manner in testifying. She was defensive when questioned by the state and tried to interject explanations when comments she made were being challenged. Again, I disagree. I thought her demeanor was fine. I've been doing this a long time. I've been practicing law for over 35 years. I didn't see anything in Mrs. Smith's demeanor or any of the witnesses that would cast doubt on their credibility. Nothing. I saw nothing like that, in my opinion. And by the way, oftentimes people are a little defensive on cross-examination. When you go at a witness hard, yeah, people might get a little defensive at times. People might, it's difficult. I didn't even sense that with these witnesses. So that's what the court said about Melissa Smith. And then another huge part of her evidence was the telephone operator, Lois Zelensik, that memo, as you recall, of her overhearing two guys on the phone talking about there's a big write-up in the murders in tonight's paper. The kid still has the bloody overalls on the trunk of the car. He's afraid of getting caught. The other guy tells him to burn him. Well, what the court says is, there's no specific mention of the Starved Rock murders. Clearly, that's what they were talking about. That was the context. That's why the Illinois State Police investigated this whole thing and traced the call. And then the court says, a subsequent polygraph examination of Zelensik concluded that she was being untruthful. Yeah. And that's what our point was, like that was ridiculous to think that they found her to be untruthful, but the brothers were truthful when the calls traced to William Palmetier's house. And then the court said, since Zelensik does not know who the men were that were talking when she overheard the conversation, there's nothing to contradict the Palmetier brothers' claims that they were not part of the conversation. Well, again, the call got traced from a bar payphone owned by Glenn Palmetier to his brother's house in Peru. The fact that William Palmatier denied making these statements, so what? Of course he's going to deny it. And I just thought it was a very naive reading of all this evidence to just dismiss her in what she heard. I thought the Lois Zelensek memo should have been considered, again, with all our evidence collectively. And I think when you look at everything I've talked about, would it probably change the trial result? And this isn't all of it. We had other things too. Yes. The answer is yes. Respectfully, our team felt the judge used the wrong legal standards, made some factual errors, and was wrong. I think the judge got it wrong, plain and simple. And I would have loved the ability to appeal it and see what a 3-person appellate court had to say. Unfortunately, with Chester's passing, we'll never get that opportunity. So it is extremely disappointing. But as I said at the outset, nobody can take away from me all we've accomplished on this journey, everything we've learned, all the evidence we uncovered. We proved the case. We showed Chester Weger had nothing to do with this. I'm so proud of that. And as like a little who down in Whoville, I'm out there holding hands with my legal team and our supporters, and we're all singing down there in Whoville, and nobody can take that away from me or any of us. We're going to continue to see what options might be out there for us to pursue this, what else we can do. I'm still going to try to investigate the case. I'm still hoping people will reach out to me if they know anything. And we'll see where things go. As I said, the fat lady has not sung. And as I said on the WGN interview with John Williams, the last chapter of the Starved Rock murders has not been written yet. Chester, rest in peace. We love you. I miss you. The story continues.